Hello everyone, welcome to Legal Darshan. In this video, we are going to discuss the case of Joseph Shine versus Union of India. It is numbered at 50 in the list of AOR leading cases. As the case goes very famous, it is one case that decriminalized adultery, which was punishable under Section 497 of the Indian Penal Code. The consequence is such that now in BNS, this section does not find any presence in the new code. Okay. Now, basically, this in this case, the challenge pertained to Section 497 of the IPC, which provides adultery to be an offense, and it was questioned that whether adultery is unconstitutional because it is violative of Article 14, 15, and 21 of the Constitution of India. Now, this case is being decided by a 5 judges bench comprising of the then CJI Justice Deepak Mishra, Justice Arif Nariman, Justice Khanwilkar, Justice Chandrachud, and Justice Indu Malhotra. Okay, now basically, adultery is being struck down in the provision of 497, which was criminalized earlier. Now, what the main questions were in this case are, okay, so yeah, this case, basically the petitioners in this case, it has been alleged that Section 497 of the Indian Penal Code that criminalizes adultery, it challenges the constitution, it is against, and it is challenged on the ground of constitutional validity, because under this provision a man could be punished for having sexual relationship with a married woman without her husband's consent, while the woman could not be punished even though she is an abettor. Okay, now the law is challenged on the ground of gender discrimination, which is, and also the violation of personal autonomy and dignity. Okay, because a law in which a male and female both are because an act in which male and female are both involved, the petitioner challenges that why there is gender discrimination, that only the male counterpart would be punished and not the female one, right? So now they are alleging that this particular provision, Section 497 of the Indian Penal Code, which is penalizing adultery, it is constitutionally invalid on the ground of gender discrimination as well as violation of personal autonomy under Article 14, 15, and 21 of the Indian Constitution. Now, the issues are very much, traceable from the arguments of the petitioner, that is to, examine the constitutional validity of Section 497 on the basis of Article 14, Article 15, and Article 21. And also a question arises in this case that whether state do have the power to, go into a private sphere, into the sphere where there is a consensual sexual conduct. Does state has to breach that public private divide and, go into making laws for governing or controlling or regulating private consensual sexual conduct between adults? Now, that is one thing that the court is also considering in this case. Okay, now the judges herein hold that Section 497 is unconstitutional and it is invalid constitutionally because, number one, this provision is patriarchal in nature and it treats women as property of their husbands. Okay, it denies women the agency and autonomy over their sexual choices, which is a very private choice that a person is making. Okay, and it is also violating Article 14 of the Constitution of India as well as Article 15 clause 1 of the Constitution of India, because there is a discrimination between men and women, both of them who are, party to the offense of adultery, if adultery is offense at all. Okay, so it is violating Article 14 as well as Article 15 clause 1, because discrimination is solely on the ground of gender, solely on the ground of sex. And it also violates Article 21 because by way of 497, by way of Section 497, the state is infringing into the personal choices a person may make and into the, choices which are made out of autonomy for having intimate relationships. Okay, so Justice Chandrachud is also observing that marriage does not mean ceding sexual autonomy, and this law, the 497 law, the Section 497 adultery, where adultery is penalized, he's observing that it is based on the notions of female subordination, which is inconsistent with the constitutional morality. Okay, no, so now basically, all in all, the 497 gets decriminalized. Okay, and Justice Nariman herein is also saying that what is punished as adultery is not adultery per se, but the proprietary interest of a married man in his life, because the intent of the law was to punish where there is adultery. It wasn't to punish where there is adultery, but rather it is to punish, that where once a proprietary interest of a married man gets infringes. Okay, so the law is archaic in nature, and it has outlived its purpose and does not square down in the four corners of constitutional morality. That is one finding of the court herein. Article 14, Article 15 clause 1, Article 21 is being invoked here. Okay, and there is a right of sexual autonomy and privacy that is granted to a person by virtue of Article 21 of the Constitution of India. And therefore, when state intervenes, okay, when state intervenes within that private sphere, within that sphere where, there is a given consensual sexual relationship, and then in that case the state is breaching the public private divide that is existing in the legal systems, and thus violates Article 21 of the person concerned. Okay, so it is also an invasion of the privacy under Article 21. However, when section whenever there is a law to be made, we have discussed in Justice K.S. Puthuswamy's judgment also. We have also discussed when we are doing proportionality. Okay, so when we did few cases relating to doctrine of proportionality, we have made this one point that there are threefold requirement that needs to be met. One is legality, another is the need of the law to be there, and the third one is proportionality. And section 497 does not stand the trifold test, which is the legality, need, and proportionality that the provision carries, because it stands failed as of today, and therefore it is violative of Article 21 of the Constitution of India. Okay, now this is which was held in the case of Joseph Shine. Basically, it decriminalized adultery, and in the light of Article 14, 15, Clause 1, and Article 21 of the Constitution of India. So, this is a brief discussion on what happened in the Joseph Shine's case. I hope the discussion was useful. Please stay tuned with Legal Darshan. Have a great day. Thank you for watching.